It's showtime at the Apollo tonight. That's all I kept thinking of. Tonight. It's showtime at the Apollo tonight. Tonight. Do 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 I don't know what I'm doing. It's showtime at the Apollo tonight. Tonight. I tell you, I can't be nothing. I think I gotta be goofy because I'm probably sleepy, so I'm probably be acting goofy. I'm gonna be a goofball. Whatever. Hey, so check it. So y'all know y'all girl did some digging. I did some digging. So let me tell y'all about this digging that I did. So when our boy Jose was arrested in 2018, they were able to connect the dots that he had committed he was involved in a shooting in Connecticut. Let me make sure I got I wrote the note down. Shoot, y'all know I be getting all this stuff. I'm almost sure it's Connecticut. Let me make sure for y'all. I think it's Connecticut. Yeah, Connecticut. So, he was involved in the shooting. It was actually another man that was accused of it. And this happened in 1993. It was reported at a barbershop. During the investigation for this case, they had learned that he had been a suspect in that case. Now, as I stated, another man was originally arrested for this incident in 1993 in Connecticut. But because the statute of limitation had already expired for a potential manslaughter case, he never got charged. Okay, so that's what that charge is about. So he never got charged. It was, at least from my research. So that's what that charge is about, and I guess that's why they can't bring it totally in. So, but let's see what we have here today for our guy. It's showtime at the Apollo tonight. Look at him, creeper. I was just like, he has done something so heinous. Like, how do you go out here and take a whole baby life and a girl life, like, all because you don't want your wife to know, to the point that she is going to know anyways, and she has moved on. So, Deborah, if you hear me out here, I have sent you a message from Take It to Trial. Please check your Facebook messages. And when you get finished, if you have to testify in the trial, if you so welcome to come on here and talk to us and explain to us and give us your insight in regards to how to recognize a douchebag. All right. Without further ado, they better not be doing all that unintelligible stuff today. I'm gonna be mad at them. They better not. Ooh. A therapist says my mind is telling me no. But my body's telling me yes. I can't sing. I'm the best chair dancer in the world, but I am not the best singer. But there is something he got to confess, y'all. Ooh wee. I'm gonna leave that right there because I see you. I'm glad you ain't say you put this song go here when we was in the other case. Because bump and grind, boy, oh boy, oh boy, would have started all types of shit. Now, I said it. Yep, I said it. We had enough grinder going on. Yeah, it was a lot of babies made to that one. I don't see nothing wrong with it. Yeah. Yeah. All right. Okay. Here we go, y'all.
All right. Good morning once again, ladies and gentlemen of the jury. As you're aware, it's my custom at the beginning of every court session to re-advise you the most important principle of a fair trial is that you, the jury, judge the case only on the official evidence presented in court and nothing else. So continue not to talk about the case or the issues or the people involved in the case with anyone, including your fellow jurors. Don't do any research in any form whatsoever and avoid all media coverage of the case in any form whatsoever. We continue with the state's case, and the state may call its next witness.
We call Elizabeth Bedola.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Hand over to the witness stand.
And you may inquire of the witness.
Good morning.
Good morning.
If you could just state your full name and spell your last name.
It's Elizabeth Bedolla, Bedolla.
Okay, and you are Tanya's mother, correct?
That's correct.
I want to show you what's been marked for identification. States Exhibit 146. Do you recognize this?
Yes.
How do you recognize that photograph?
She's my daughter.
Okay, and is that your daughter from when she was alive?
Yeah.
This time the state would move into evidence what's been marked for identification as States Exhibit 146.
No objection.
That item will come into evidence without objection.
And this time the state will just publish what is marked or entered now as States Exhibit 146. Thank you, ma'am. I don't have any other questions.
Any questions from the defense?
No, Your Honor.
Thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. People say before I call Rose Rosario.
If you can raise your right hand and face the clerk.
Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Please. Thank you.
Over that way to witness.
And you may inquire of the witness.
Morning.
Good morning.
Can you state your name for the record and spell your last name, please?
Yes, Rose Rosario, Rosario.
Okay. And Ms. Rosario, what do you do for a living?
I am a interpreter, translator, transcriber practitioner.
Okay, go ahead and give the jury a thumbnail sketch of your education, your training, and your experience, please.
Yes, good morning. I was trained by the Uruguayan Air Force. I was a diplomat interpreter, translator, and transcriber. Later, I started working in 2004 with homicide units for the 19th Circuit Court, and then with the 17th Circuit Court, doing transcriptions and translation.
And where is the 17th Circuit?
17th Circuit is in Broward,
Broward County?
the Broward courts, yes.
Okay, I didn't mean to cut you off. Go ahead.
No, no problem. I got my certification in 2012 as a transcriber, translator practitioner. And I've been working the field close to 21 years.
Okay, and just some background questions. Where did you grow up?
I grew up, I was born in Cuba. I came when I was in the second grade, so I was raised in Hialeah, Miami area.
Okay, and were you raised in a home where Spanish was the primary language?
Yes.
Okay.
Yes, it was.
And did you learn English? Obviously, you know English, right?
Mhm.
Okay, and how well do you know Spanish? It's obvious, but how well do you know Spanish?
Oh. Very well. My parents made sure that the Spanish language was not lost when we started school. So we had to take Spanish lessons all the way from elementary to high school.
Okay, and did your parents, did they only speak Spanish, or were they able to learn English as well?
No, they learned English. They were nurses, so they
Okay.
learned English.
Okay, good. And did you have any formal education in Spanish?
No, not formally, just the one that you take in school, advanced Spanish. And Spanish was always spoken in the at home.
Okay,
And then I married into a Spanish home also.
okay. And you said that you worked for the Uruguayan Air Force?
Yes.
Okay, go ahead and describe that experience for the jury.
Okay, I worked as a diplomat, interpreter, translator, and transcriber.
Are you
So,
having difficulty hearing the witness? If you could keep your voice up.
oh, I'm sorry. Okay, at the Uruguayan Air Force, I was trained as a diplomat, interpreter. I was the interpreter for the assistant air attaché. So we did all the interpreting for all the foreigners, vendors that came into the office. I translated everything that was done in that office was received in Spanish and had to be translated into English. And then with the vendors, it had to be translated back from the English into the Spanish to give back the responses to the Uruguayan Air Force. It was your purchasing office.
Okay, and you did that for how many years?
5 years.
40 hours a week?
Yes.
Okay, and from that point forward, where did you go and what did you do as it relates to to Spanish and Spanish translation and interpretation?
I started, let's see, in 2004. I went back, I got away from the interpreting field for a little bit. I did real estate. Then in 2004, I got back again into the interpreting field. And I started working with 19th Circuit Court, doing the transcribing for jail calls, confessions, everything pertaining to homicide cases.
Okay, and go ahead and you mentioned that you had obtained a certification.
Yes.
Can you explain that to the jury, please?
Yes, in 2012, I got a professional certification for the transcribing, it's called transcribing translator practitioner. And by that time, I already had acquired about 5,000 hours of transcribing and translating for the Uruguayan Air Force. From 2008 to the present, I've acquired 4,500 hours in homicide cases for translating and transcribing.
Okay, and to be clear, the primary language of Uruguay is Spanish.
Yes.
And describe the transcription process for the jury. Tell the jury about that.
Okay. First, we get the sound file or the audio files. We listen to it. You have to listen to it several times before you start transcribing so that you can get familiar with the voice, the speech pattern, the volume. Once you hear it a couple of times, then you start the transcribing process. The transcribing process is done before you start the translating part. Once you have that, if you take a look at the format, you have a column that's in Spanish and a column that's in English. So once all the transcription is done, it gets proofed. We proof it to make sure that we've got everything down that was transcribed. After that portion is done, then we start with the translating part.
Okay. And let me ask you this. Is there a difference between translation on one hand versus interpretation on the other?
Yes.
Okay.
Yes.
Explain that distinction to the jury,
Okay.
please.
So the interpreters interpret orally. The translators, we do documentation, word documentation. Everything that's in the written form, it's a translator. Versus the interpreter, which does oral.
Okay. So as a practical matter, is there a big distinction between the two? Describe the distinction in practical terms to the jury.
Yes, there's a big distinction. It's two different professions. Sometimes there are translators that also do interpreting, and the same way interpreters that do translator, but it's a different field. Interpreters go in and out. They interpret on the fly. Translators have more time to work with the document. We're able to research and go over and over again the document or the files that we're working with.
Okay. So, and again, to put it in practical terms, let's say I were to call a witness who only spoke Spanish. Would you be the person to interpret that to the jury, or would you not do that?
No, that would be an interpreter.
Okay. So to be clear, what you're doing is translation. You're not doing interpreting.
Correct.
Okay. Okay. Thank you. Okay. And were you provided some evidence in this case, the state of Florida versus Jose Soto Escalera?
We were provided with sound files and videos.
So I'm going to show you what has been marked as State's Exhibit number 169. Do you recognize this?
Yes.
Okay. What is that?
This is the denoised audio video, about 11 hours long
Okay.
that we worked on.
Is that an external hard drive that contains the audio and video and all the materials you reviewed
Yes.
in order to arrive at your conclusion in this case?
Yes.
Okay. And did you translate the August 24th, 2018 video and audio from a Waste Pro garbage truck?
Yes.
Is that what's on there?
Yes.
Okay.
Yes.
And did you reduce your findings to a written transcript?
Yes.
Okay. And does that transcript reflect what you listened to when you listened to exhibit number 169?
Yes. Mhm.
Okay. And Your Honor, permission to publish using the same procedure we did yesterday?
You can ask the witness questions about content of sections of the item.
He's referring to having another person come in to read.
Oh, okay, yeah, but in that form, yes.
Yeah,
You do that.
okay.
Okay.
We're going to go get Mr. Blanc. And while we're doing that, tell the jury how many hours that you spent on exhibit number 169 in arriving at your conclusions?
Okay. Like I said, it was an 11-hour video. We spent close to 110 hours, between 110 to 150 hours working on the videos.
Okay. Okay. Over a period of how many weeks or months?
About 2 months, 2 to 3 months. Because the way you do this, you can't work on these more than 5 hours. It's too exhausting. So we do sessions of 4 to 5 hours tops.
Okay. And, okay. Here's Paul.
Do you have a copy of your transcript? You can use it. Morning, John. Morning. Okay, so Ms. Rosario, can you, we'll start off on page 1. And Mr. Belanca will play the role of the individual that can be more audible. Ms. Rosario, you will play the role of the individual that is less audible. Does that make sense? As we described in my office?
Yes.
Okay. Okay, so we'll go ahead and start on page 1. Ms. Rosario.
Know what's crazy? All these gloves are,
Throw all that out.
it's garbage.
Inaudible.
Where the hell is the ox tape at?
That's in the bag. Oh, Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I would have, unintelligible.
Well,
You can't be mad at people.
huh?
You can't be mad at the people.
Yep.
We can throw it in there.
Put on the gloves.
Okay.
Objection, Judge, really,
Yes.
Let me return to line 20. You follow me, Ms. Rosario?
Yes.
Okay, line 20, go ahead and read all of that particular section, please.
Okay. We can throw it in there. Put on the gloves.
Line 21.
Okay. The ones of that black.
Okay, we'll go back. Line 20, Mr. Belanca. Go.
We can throw it in there. Put on the gloves.
The ones of that black.
Yeah. Stay with those. Don't because they have my prints. Pretend that so that nobody sees you. Sure, it's good. Right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up. We'll do it inside, man. It's best. It would be good with trash.
If it don't work out, okay.
back and forth through there. It's coming.
Take it out of the bag, put on the gloves. Take it out that I'm going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro.
Yeah, ain't nothing outside.
That was incorrect. You need to go back. As far as who speaks the line, correct? Sure. Jury, let me ask you to step back into the jury room for a moment so we can sort this out. We'll be with you momentarily. Please leave your notes in your chairs and do not discuss the case.
I don't care how many people they bring in to try to translate this mess. Like, really?
Transcript is being highlighted to avoid the wrong parts being spoken. Go off the record momentarily.
I wonder if this will bring up anything in regards to a an appeal. Because I mean, this is ridiculous. They don't know what they're doing. This is the third interpreter coming in. Look, they both got a highlight. Like, this is the mess. And if they want this in so bad, they don't know what to do.
Evidence is the testimony, not the transcript. The transcript will not be available, so they could take notes. You're still doing the highlighting?
Yes.
Okay, take your time. The jury that the transcript will not go back into evidence? I don't believe I have. I think I should,
Yes, sir.
because they're going to ask for it,
Oh, yeah.
just to be sure that this is just being used to assist putting the evidence on. The evidence is the testimony, not the transcript. The transcript will not be available, so they could take notes.
Yes, sir.
Okay,
Yeah.
so I will do that as well before you get started.
I'll clarify both transcripts.
What's that?
I will clarify both transcripts for the one yesterday as well as today. If that would be okay.
What do you mean? I'm going to instruct them on it.
No, yeah,
That's
but
what I mean.
we didn't
Neither
tell them
transcript is
Yeah,
going to go back,
yeah.
not just this one.
Right,
Yeah.
okay. Still doing the highlighting. Okay.
That's true.
I'll have those 3 lines right now.
Give me 1 second.
Who was the person speaking?
What you told me about page 3, line 37.
Okay, so, on page 3, the box 37, they stepped out of the truck. So we were not able to see who was the person speaking. I just transcribed the conversation as I heard it without designating anyone because I wasn't able to see who was doing the talk.
Because you asked that question struck from the reading, as we cannot attribute it to what we're now calling the closer participant and the further away participant.
No objection.
All right, so you're both agreeing just not to read that?
Correct. Yes, yes, sir.
Entry 37. Okay, that's fine. Otherwise ready for the jury? They're still doing the highlighting?
Yeah,
Okay.
lots of boxes here, sorry.
Go off the record momentarily. Correct.
who the speaker is.
Just off the record, Mr. Richardson said no one's reading MV3, and that's not accurate. The state's going to read MV3
I'm gonna read
on the other
MV3 on
page.
page
Okay.
Yeah, I thought you were talking about the,
37.
we did.
No one's reading
He's
37.
reading
Correct.
Yeah.
I'll go off the record momentarily. I'm going to tell them we're going back to the start. I'm going to tell them about the transcripts not being evidence, the evidence being what's said in court, and give them instructions on that to assist them in deciding whether to take notes. Evidence, there was some slight mishaps, which is going to cause us to go back to the beginning. You should know the testimony in this regard is going to be much shorter than the one you experienced previously. Also, I wanted to tell you before we get started, too, as I've mentioned, it's up to you to decide whether or not to take notes. But in making your decision, I think you should know this information. With regard to the translation evidence, which is what we're doing here, the evidence is what is being said in court here. The transcripts themselves that the witnesses are using to do that are not evidence pursuant to law and will not be available to you during deliberations. So please be aware of that. You should know, though, too, during deliberations, should you need to, you do have the ability to re-listen to the testimony, to be brought back into the courtroom, and I would replay the testimony to you. You would have to hear the testimony in its entirety unless we were to determine otherwise, but that is the default legal position. So I just tell you that in your decision whether to take notes. And as I mentioned before, disregard what you heard previously because there are some slight errors in it. We're going to go back, the state's going to go back and restart the testimony in that regard. And you may do so, Mr. Richardson.
Yes, sir. Thank you. And Mr. Zari, before we begin, are parts of this also in English that the speakers are using? Are they using a mixture of Spanish and English, or is it completely Spanish?
Sometimes it's in Spanish. Sometimes they use what we call Spanglish, which is a word that it's anglicized, or they switch code, which is they speak in a sentence in English and Spanish.
Okay. And a few more questions. Are you familiar with Spanish that's like variations of Spanish, like Puerto Rican?
Yes.
Okay. Explain briefly to the jury your experience with Spanish derived from Puerto Rico.
Okay. Although I was raised in a Cuban family, my husband, whom I was married to for 25 years, is Puerto Rican.
Okay. Do you have any trouble or difficulty understanding Puerto Rican?
No.
Puerto Rican Spanish?
No,
Okay.
the regionalisms, no.
Okay. All right. So now we're going to start again, and we're going to start on page 1.
Mhm.
And we're going to start with line.
The other part where Mr. Cormier is going to be assisting what's going on there.
Yes, Ms. Rosario, is it your understanding that Mr. Cormier, is there a third participant within this particular item of evidence?
Yes.
Okay, explain that to the jury.
Yes, there's a third participant, which is when they get to the weight station and the guy that's doing the weights, the scales and all.
I'll just give a very brief explanation of why someone else is speaking. Without,
without getting into what you saw and what you heard, just why is there a third party there?
Because they get to the news station and
Just as far as the voices heard and why there's a third speaker, just focus on that, not with regard to the, what's going on in the context.
we designate a voice number for everyone, for every speaker that we hear. So number 3 would be that person.
Number 3, again, is an unknown party.
Correct.
Okay, gotcha. Okay, so we'll go ahead and start.
Okay. Know what's crazy? All these gloves are inaudible.
Throw all that out.
It's garbage.
Inaudible.
Inaudible. Where the hell is the aux tape at?
That's in the bag. Oh Lord, I'm tired.
Can't stop thinking about that. I have provided a lot.
Huh?
Things that are running in my head.
Why?
Can't think about it later. That I should have, I would have. Inaudible.
Well,
You can't be mad at people.
huh?
You can't be mad at people.
Yep. We can throw it in there. Put on the gloves.
The ones of that
Yeah.
black?
Yeah. Stay with those. Don't let, because they have my prints. I'll pretend it nobody so that nobody sees you. Sure, it's good right here, bro.
Just open the door.
We can throw it out in the España.
Inaudible. Almost there. Inaudible.
Can back up? You know, we'll do it inside, man. It's best. It would be good in with trash. If it don't work out, okay.
Back and forth. Back and forth. Through there. It's coming.
Take it out of the bag. Put on the gloves. Take it out that I am going to inaudible. Sure, it's right here.
Who's gonna find a gun there, bro?
I don't know, bro. Yeah, ain't nothing outside.
Up to there is good.
Put it on the floor then.
Huh?
Put it on the floor.
If there are many cars, forget it. Go back.
Don't look that way. I'll tell you, inaudible. Ready to come inside?
Here. You don't have any messages or anything like that.
Where?
Of hers. Online.
Threatening her or something like that?
No.
No, none of that.
No. No.
There's none of that.
Inaudible. No. Inaudible.
Let me go see something. I did inaudible things. Good.
I could have done it alone.
Huh?
I could have done it.
You know why I showed my face? So that they don't assume.
Take the right. Where the hell are you going, bro?
When I get home, I have to go check it right there. You know what I need from you? Keep me occupied so I don't think. I was talking to a policeman friend of mine about things like this. He says it is not proof of anything. It is inaudible standard. That is not
Yeah.
like a revolver that leaves prints.
As soon as I walk in, all she looks at me and she says, inaudible. Somebody else. Inaudible. 6:45, bro. And don't call.
I left at the house 5:05 on top of the fucking pad.
Huh? Telephone call. Hello? Hey?
I have to go to the house. Got to go to my house right now. You hear me? Got to get something. Yeah.
Telephone conversation. I'm on the road. Inaudible. Can't get to inaudible. Oh, that's what I'm saying. I'm on the road.
Is she still at the house?
Huh?
At her house?
She's leaving. She told me she would like inaudible. Oh, God.
Well, I'll see you at the house because I have 4 cartridges bags on top of the pickup truck there that match the cassettes.
Where are you going to pick it up?
Now, move, dump that, go to the house. Should I tell Mike, inaudible, I'm driving and my wallet I left at home?
Can't be fucking. You can't think too much. You can't be back and forth because that's how you get caught.
That's tough.
You gotta act calmer.
Yeah, the auxiliary port cord. It's there in that bag.
Huh?
The auxiliary, I'm saying the wire.
I had it there, right there. This part here. You put it in.
Hold on a second.
Mr. Rosario, can you please restate number 72 on page 5?
Yes. I had it here, right here, this part here. You put in the output and this little thing. You just put it, I put it right there and it all stays.
It's rolled up in that little black thing. You'll see it. It's in the top zipper. Where are you at? You're in the wrong place. There, right there. Should be wrapped up in a little black inaudible.
Inaudible.
I'll do it. Tell me what it is saying.
Welcome, right there. Inaudible, right there, inaudible. Main road,
Already dropped the kids off?
inaudible. Did she have any money yesterday?
Huh?
She didn't have any money on her?
I didn't have time for that.
She didn't have money?
I don't know. Why?
Was asking. I should have went. I
think it.
Man, they're killing their beat, bro.
Why?
They went through his road.
No, he didn't.
Yes, he did. Inaudible.
Who's the driver?
Johnny.
That means he's in there then, right?
Oh shit, that's a Waze Pro truck.
Yeah, put some like Aventura, like Ashada shit like that. Go on. Do you have some Romeo?
Huh?
Romeo Santos?
Santos? What kind of bullshit is that one? Definitely dirty.
That's inaudible dad.
Huh?
His dad.
Where?
In that yellow inaudible GTO.
Ah, my head keeps on hurting.
Inaudible.
Inaudible.
What time is it?
8-something. 8:16.
Let's see what the fuck he said.
Who? You wanted to go. Inaudible, right?
No.
Yawns out loud. Inaudible. You got one more.
Huh?
Inaudible. Up front.
Huh?
Inaudible.
I want to do it when I get out of here.
Inaudible.
Huh?
No man can be happy. Oh, that's all I need.
What?
I'm totally fucked.
Do you have water in there?
Inaudible.
Huh?
Inaudible. Something burnt?
Put something Traviano.
One's life, bro.
I need a fucking drink.
What are you going to do with this?
I have food.
You're gonna eat salad? We're here.
Get me a drink. My fucking mouth is dry.
Huh?
My mouth is dry. Did you hear me? Can you grab me a Monster or a Gatorade?
What?
Hey, inside.
You want a inaudible?
Huh?
Ain't it?
Huh?
Inaudible.
Who?
You.
An orange one?
Inaudible.
Good.
Now you know how I feel when I get no sleep. I get dehydrated the next day.
It's hot out.
Eat this, inaudible. The dehydrate will go away.
I like when inaudible.
If you eat this, you get hydrated.
You don't want to eat it? The last one? Fuck you, bro.
Nasty.
Want a sandwich? Hey, want to put your music on? Tastes good, right? Fuck that sandwich up. Rice and beans with ham?
Not yet. Why don't you turn it on? Hey, this bitch is bad enough, inaudible. Lip syncing. Like right there.
There?
Lip syncing. What happened, bro? You're falling asleep.
I'm falling asleep. I'm going to take a 30-minute break. You have to put the one of inaudible Gil. Put on the heavy music.
Lip syncing.
Do you know how I feel now? Like in a beer mode. I'm thinking crazy, I know. I'm going to have to feel as if I'm going out on a bank, bro. I'm inaudible if I have to. Can't do that though. Inaudible.
Can't do that too, inaudible. Because I have to be calm like that now. Everything to them. It's fine.
Did she have a purse? Hers? No. If they find her now, they can't do the inaudible final because the mom is not called. She is not missing yet on this side. They don't consider her as missing. The what? What did she die of? What did she have? What does she have? So they will put her in a box, take her out, the son, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths when I got to her house, and I bathed this morning. I bathed. I cleaned my hands with the cleaner, the one for breaks. because I had gloves and everything just in case.
Did you see the blood?
Huh?
Did you see blood? Did you see?
I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag.
Inaudible.
Exactly. What's for dinner tonight, bro?
Huh?
What's for dinner tonight? I'm thinking pizza. You know, I can't go to that street no more.
Which, that one?
By that street.
You're confused with the streets like that.
By there no more with this truck. They can watch me also with that.
This is a work truck, man.
Huh?
This is a work truck. Inaudible.
Right. Did you make the landfill? Inaudible. Everything?
I hope so.
Inaudible. I want to move forward and get out of this mess. You got to run through this side right here. It's bigger. Inaudible.
Inaudible.
Hold that. Hold on so I don't lose it.
Lip syncing.
You said there should be one over here?
Huh?
Huh? There should be one over here?
Nothing there.
Huh?
Nothing there. Inaudible. Bro, look at her hair. Laughs out loud.
Watch there. From the back.
Inaudible.
Who?
I'm starving, man.
We'll get a little piece of food. I have to put my plate back of that. I'm going to put it there. The plate, put it back.
Of your car?
I took it off. The one that says Puerto Rico, I took it off. I have to put it back on. Do you smell that burnt shit? Smell it. What is that?
I don't know.
You smell it though, right?
Yeah, keep your eye on it. Can be your battery. Did it start otherwise right? Keep your eye on it. Radio still working?
Yes, sir. Thank you. He waved at us and everything.
He said it audible. Inaudible.
Huh?
Inaudible.
He waved at us. Nice and easy.
All right. What do you feel like cooking tonight?
I don't know.
All right, look.
That's probably what it is.
What?
The batteries. Thank you.
Okay, Ms. Rosario. To do one more item here. Did you, were there portions of these videos and audios that were more difficult and less difficult to hear? Were more of them audible and some of them unaudible, or what? Can you explain that to the jury?
Yes, they were. All this was taking place in a truck, so there was a lot of noise, and he had the radio on also. It was difficult, but doable. We took a lot of time with it.
Okay. I'm going to go ahead and publish, I'm going to go ahead and publish a part of it. And if you could translate that portion, and if you need to, refresh your recollection with the transcript. Does that make sense?
Yes.
And for the record, the portion that we're going to start on is page 10, line 167 at 5 hours, 59 minutes and 48 seconds. Okay, Mr. Rosario, ready?
I'm sorry, could you repeat the portion, the
So
section?
we're going to go to page 10,
Mm-hmm.
line number 167.
Okay.
Ms. Rosario, if you could refresh your recollection and tell the jury what was said at that point.
On that side, on that portion, he was saying, no, if they find her now, they can't do then it was inaudible. Final, because the mom has not called, she's not missing yet. On the side, they don't consider her as missing. The what did she die of? What does she have? What does she have? So they will put her in a box, take out the son, inaudible, problem. And since she disappears like that for a couple of days, no one is going to be looking for her. I already took 2 baths. When I got to her house and I bathed, this morning I bathed, I cleaned my hands with a cleaner, the one for breaks, because I had gloves and everything just in case. Did you see the blood? Did you see the blood? Did you see? I had it all over the clothes, but without the evidence, they can't do nothing. If something happens, no one saw the bag. Exactly. What's for dinner tonight, bro? What's for dinner tonight? I'm thinking pizza. I think that's somebody.
Okay, thank you. And to be very clear, the person who said I had it all over the clothes, but without the evidence, they can't do nothing, was that the individual that was easier to hear?
Yes, that was,
The individual that was easier to hear?
yes, everyone, yes.
Okay, all right, thank you. Ms. Rosario, I appreciate your participation. I have no further questions. The defense counsel may have some for you, okay?
Cross-examination.
Thank you, Judge. Ma'am, how many times have you testified in court?
This would be about the 7th time.
7 times. How many times of those were for the defense?
I believe a couple of times.
A couple?
Yes,
How many?
2 times.
2 times. Okay. You said that you spent 110 to 150 hours working on what we just heard.
Yes,
How much do you get paid an hour?
$95 an hour.
$95 an hour. Okay. You did a certification for that transcript that you just did the reading up. Is that right?
Yes, yes.
Okay. And on your certification, you said pertaining to this case from 8/23/18 is a complete and correct transcript translation from Spanish to English. Is that right?
Correct. Yes.
Okay. So you certified that this was from 8/23/2018, correct?
Yes.
Okay. No further questions.
Any questions? Further questions from the state?
If you look at your certification, 8/23/18, is that a typographical error?
I don't have the,
If I show you the certification, will that refresh your recollection?
yeah, I mean, if that's what I have. Oh. Okay, that's a typo.
Okay. Does the video, go ahead and read the video, title of the video and evidence to the
Yes.
jury, please.
The title is,
I'll sustain the objection. I believe the item that's referred to is not in evidence, so to asking for the witness to read something that's not in evidence.
Okay. Can you tell the jury this title is?
Objection.
Yeah. I'm going to show you the electronic copy of the file.
Objection.
From
Judge, can we reverse?
Exhibit 169.
Let me wait for a question. Let me see what the question is.
Okay.
The previous objection was sustained because the witness was being asked to say something to the jury regarding something that's not in evidence. If you're using it to refresh her memory, you need to ask a substantive question. You can assist her in answering the substantive question. She can't ask her a question to read something that's not in evidence. So
Yes, sir.
going forward with that clarification, ask another question.
Yes, sir. If I were to show you an electronic copy of the file that you used in arriving at your conclusions, would that refresh your recollection as to the date of the translation, as to the date of the video that of the reporting in this case?
yes, it's 8/24. There was just a typo where I'm referring to pertaining, but the body of the certification has the correct date,
Okay, so
8/24.
tell the jury again, what is the correct date of the video that you translated?
The correct date for the video is the one I have right on the text.
You need to answer the question without referring to the document.
Okay, yes, the correct date is 8/24/2018.
Thank you. That's it.
Any further cross-examination?
Just briefly, but on the thing that's called a certification, you wrote that the date was 8/23/2018, correct?
That's in the bottom part. On the main text, it has 8/24.
I'm asking on the certification itself, the thing that's called certification. You're looking at it right now. It says 8/23/2018, correct?
That's the second part.
Okay, so we didn't even get that correct, right?
We have, it is correct. On the main, what I am, the title that I am certifying
Ma'am,
is
ma'am,
8/24/2018.
permission to approach the witness, Judge?
You
I'm talking about the document entitled certification. This is the document.
Correct.
And that where the date is, the certifications is 8/23/2018, correct?
That is not the certification. This is a preliminary certification which was emailed because they were in a hurry.
Okay.
To show the judge. This is the final one. And it's got all the information.
Oh, so we got it wrong in the initial one and in that one, correct?
It is not, well, over here on the second part,
It says
8/23. But the text, what I am certifying is correct, August 24, 2018.
Okay, but it says 8/23/2018.
Objection.
At the bottom is a typo.
I'll sustain the objection. I think it's been asked and
certification
answered at this point.
No further
Any
questions.
further questions from the state?
No, sir.
May this witness, Mr. Rosario, be released from subpoena at this time?
Yes, sir.
Any objection to releasing the witness?
No, Your Honor.
You may be released from your subpoena. You're free to stay or leave as you wish. Thank you. You may step down. And the state's next witness or item of evidence.
Yes, sir. The people say the floor recall Detective Chris Newman.
Raise your right hand, please, clerk.
Do you swear affirm that evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
And you may inquire of the witness.
Morning.
Good morning, sir.
Can you state your name for the record and spell your last name?
My name is Christopher Newman. Last name is spelled Newman.
Okay. And during the course of your investigation, did you learn the location of the defendant's residence in August of 2023? Or, I'm
Yes.
sorry, August of 2018.
Yes, sir.
And what was the location of his residence? What was the street address?
I know it was on Cactus. The exact address escapes me right now.
2613 Southwest
Objection,
Cactus?
Judge. Leaving.
I'll sustain the objection.
Did the defendant live at
Objection,
2613?
leaving.
Does not suggest.
I'll overrule the objection. It's an open-ended question.
Did the defendant live at 2613 Southwest Cactus Circle?
Yes, sir.
And was a search warrant executed on that residence?
Yes, it was.
On what date?
I believe it was August 28th of 2018.
Okay. And did you recover, did anyone from the sheriff's office who executed that search warrant recover any clothes with blood on them?
No, we did not.
Did you recover any weapon with blood on it?
No, sir.
Okay. And sir, that is all the questions I have. Thank you.
Cross-examination.
No cross.
At this time, may Detective Newman be released, or you wish for him to remain under subpoena?
I wish to ask for a ruling.
Please step down, Detective. You do remain under subpoena. And the state's next witness or item of evidence.
Permission to approach.
Sure.
Before we bring that, this is the one this is one of the safety exhibits, that's the hard drive, it's
169.
169, we're gonna have it up and open, we're not gonna play from the video, he's gonna play an audio portion, but we're gonna start with this already up. Which, it's in evidence, they can view it, but I'm just making sure if there's any issues beforehand, I want
Which one was the 169? Which translator person?
August 24th with the person.
With the one that was just testified to. So this is the video and audio portion. And they're just playing overlapping portions.
We're not even playing it, we opened it where you can see a pickup inside of the
Picture of
truck,
what
you
it
can
looks
see
like.
some people, someone
Okay.
driving and someone in
It's
passenger.
just stills.
This is a video, but it's
Okay.
paused.
Okay.
after they do their identification, we're going to take it down and then we're going to play audio.
Okay.
And then following that, we're going to do the same thing with the exhibit number 170, which was testified to by.
I just want to be sure that what you're playing is what has been testified to.
It has, and we are not playing any portion that we agreed is redacted.
Okay.
Perfect.
Yeah, okay, very good. Let's bring in the jury. All right, the jury is present and we proceed with the state's next witness or item of evidence.
Yes, sir. The people of the state of Florida recall Adolfo Cavelli.
Raise your right hand.
Yes, sir.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Yes, sir.
And you may inquire of the witness.
Good morning. Can you state can you state your name for the record and spell both your first and your last name, please?
Yes, sir. Adolfo Cavelli, Adolfo, last name Cavelli, C-O-V as in Victor, E-L-L-I.
Okay. And I believe you testified a few days ago. Were you a senior official at the Waste Pro location here in Fort Pierce in August of 2023? Or I'm sorry, August of 2018.
Yes, sir.
Okay. And were you familiar with the trash routes of the drivers in August of 2023?
Yes, sir.
Okay. Were you specifically familiar with the trash route of the defendant, Jose Soto Escalera?
Yes, sir.
Okay. Did he have a trash route in northern Fort Pierce?
Yes, sir.
Okay. Can you tell the jury what his trash route was?
Yeah. I can't give you the exact every road and all that, but it was in North Fort Pierce, in the Andrea Road area, Johnson Road, Rousseau Road, around the Spanish Lakes area, in northern Fort Pierce, St. Lucie County.
Okay. And can you walk the jury through was there a system in place where each of the employees of the Waste Pro, if they were on a garbage truck, what was their knowledge of the camera and recording system?
Yes, sir. So I was there when we had the cameras installed, and every employee that was in the vehicles had to acknowledge that they were being recorded both by audio and visual recordings.
Okay. So did every employee who was assigned to one of those garbage trucks have specific knowledge that they were recorded?
Yes.
And that they were videotaped?
Yes.
Okay. And how well did you know the defendant, Jose Soto Escalera?
He was an acquaintance and an employee, like most of the employees. I was very close with them to get to know their families and ask about them. And Jose was one of those people too.
How long do you think you knew him?
I would say backing up from 2018, a few years. I believe Jose worked for us and then left and came back. But regardless, I've known Jose since his employment at Waste Pro.
Did you have many conversations with him?
Yes.
Did you know him it sounds like you knew him in the context of work. Is that correct?
Yes.
Did you also know him socially?
Yes. Yes.
Okay. Do you know him well enough to visualize him, identify him?
Yes.
Okay. We're looking here at a freeze frame of one of the videos from exhibit number 169. If you need to, step down, but do you see Jose Soto Escalera on the smart TV?
Yes.
Okay. Can you identify him? Which one is he?
The gentleman with the glasses and the steering wheel in front of them to the right of us looking to the right.
Okay. And who is the other individual in the vehicle?
I'd like to come up with that.
Who is that?
The helper of the route, Eric Alvarado.
Okay. And did you speak to Jose Soto Escalara enough to recognize his voice?
Yes.
Okay. And based on that familiarity, if I were to play you a clip from an audio of exhibit number 169, would you be able to recognize his voice?
If I hear it, yes.
Okay, so for the record, we're going to go to page 10, line 167 of the transcript. It will be at 5 hours, 59 minutes, and 48 seconds. I'll stop it right there. Did you hear two voices in that clip?
Yes.
Was one softer and one more audible?
Yes.
Okay. And are you familiar also with Eric Alvarado's voice?
Yes.
How long had you known Eric Alvarado for?
Since his time of employment, I don't recall exactly how long. It was a shorter time period than Jose Soto.
Had you had multiple conversations with Eric Alvarado?
I'd greet the team every single morning, all the employees. Yes.
Okay. And can you tell the jury the identity of the individual whose voice was less audible in the clip?
The one that had a lower voice?
Yeah.
Eric Alvarado.
Okay. And can you tell the jury the identity of the individual who had a more clear and more audible voice?
Yes, that would be Jose Soto, Escalara Soto.
Okay, thank you. I will now want to show you. Yep. Now we're going to publish States 170. Okay. Okay, I'm going to show you a video from August 21st of 2018. Okay, yeah. Yes. Okay. Are you? Can you take a look at those individuals in that? Oh, that's working.
Yes.
Okay. Do you recognize who the driver is?
Yes.
What's his name?
Jose Soto Escalara.
And do you recognize who the passenger is?
Yes.
What's his name?
Eric Alvarado.
Thank you. Yeah. We'll go to August 23rd of 2018. Video. Yep. Here we are looking at a video from August 23rd of 2018. Who is the driver
Jose Soto Escalara.
and who is the passenger?
Eric Alvarado.
And here we are looking at August 25th of 2018. Who is the passenger?
With the sunshine, do you mind if I walk up, please?
Sure.
Thank you.
What's the identity of the passenger?
The passenger is Eric Alvarado,
And the driver.
Jose Soto Escolar.
Okay, same question on the video from August the 27th of 2018. Who is the driver?
Jose Soto Escolar,
And who is the passenger?
Eric Alvarado.
If we could return maybe one more. Sir, thank you very much. That's all we have left.
Thank you.
Any questions from the defense? May Mr. Cavelli be released from his subpoena at this time?
Yes, sir. Good.
Thank you, Mr. Cavelli. You're released from your subpoena. You're free to stay or leave as you wish.
Thank you very much, sir.
Thank you. And the state's next witness or item about.
Your Honor, at this time, the people say for arrest.
Ladies and gentlemen of the jury, at this time, the state has arrested its case. Let me ask you to step back into the jury room for a moment. Please do not discuss the case and leave your notes on your chairs, and we'll be with you momentarily. All right, the jury has exited the courtroom at this time. The state has arrested its case. Any motions from the defense?
No motions from the defense.
Okay, and from the defense, no witnesses other than whether the defendant is going to testify. Do you need time to confer? Sure, confer with the defendant to make a decision whether he wishes to become a witness. I'll inquire of him in that regard, and then we'll go from there. But we'll go off the record, giving the attorneys a chance to speak with the defendant to make that very important decision. Go off the record. His decision to become a witness at this time. Mr. Soto Escobar, you can be seated with your raise your right hand. The clerk will swear you just for a brief inquiry from me on that particular point.
Do you swear affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Mr. Soto Escobar, the decision whether to become a witness in the case, unlike most decisions in trial, is personal to you, meaning you receive the advice of counsel, but you make the decision up and above their advice. If there's a disagreement as to whether you should testify, you get to make that call, even if you disagree with your attorney. You have received their counsel. First of all, do you understand the decision is personal to you?
Yes, sir.
Are you deciding to testify or not?
Not, sir.
Not. Are you doing that of your own free will?
Yes, sir.
I will find that you're making the decision not to become a witness freely, knowingly, and voluntarily. We'll proceed in that fashion. And therefore, let's discuss the plan. My suggestion is to release the jury till when they come in, have the defense rest, release them till 1 o'clock. We'll do a quick charge conference and give you the remainder of the 2 hours to polish your closing arguments and proceed at 1 o'clock. Is that a good plan?
I think the parties might have agreed a different plan, Judge.
Okay. Well, I'm open. I'm open. I'm just, okay. I know we talked about finishing tomorrow too, which is possible. Is that what you had your eyes on?
Yes, sir. If that would be okay with the board. Yeah, Friday works better, if that's okay. We've had a long 3 weeks.
I'm open to that. Of course, the advantage if you do it this afternoon, I realize, I've done your jobs as well. So I realize, what goes into a closing argument. The advantage is if there is a conviction, you get tomorrow off to prepare. there's that too. But either way, is that what you both agreed on?
Yes, sir.
Okay, that's fine with me. All right, so then I would bring in the jury, have the defense rest, and then tell them they're excused for the rest of the day. We'll do closing arguments tomorrow morning.
If you have a suggestion,
Sure.
you can deny it. What?
Rest tomorrow.
No, I don't mind resting now. I was just wondering if we could do the charge conference now and charge the jury today, and that way when we come back tomorrow, we could just go straight into closings and then they deliberate.
Copy.
You want me to read the instructions to them before your closing arguments?
Yes, sir.
State agree?
Read all the jury instructions before?
Correct, that's the
Yes.
request.
You mean today or tomorrow?
Today.
That way we make good use of the time.
So then what we would do closing, and then you would remind them and say, I read you the law yesterday,
Yeah, I've never done that, but it's a standard practice with other judges. There's nothing wrong with it.
and they're gonna get a copy of it anyways.
Exactly.
Copy.
I just think that'll give them something to ruminate
Saves
over
time.
I
tonight.
have no problem. It's time efficient for me. And I would always wonder whether there's not more requests to do that because they'll know what the law is before you make your arguments as opposed to the other way around.
Exactly.
Okay. And I'll tell them the attorneys have agreed with this procedure. I'm going to instruct you on the law and then they're going to make their arguments tomorrow. Don't form any definite or fixed opinion. At this time, you haven't heard their arguments.
Correct.
Are you going to tell them in the instructions about their ability to review the testimony again? I think the only issue was the way it was said could be interpreted that they have to listen to the whole trial and that that rule only applies to individual witnesses.
Well, let's do the charge conference now.
Yes,
Do you have my latest?
Yes, sir.
You have my latest email in that regard. I just took out, obviously, the defendant has become a witness. What I have remaining for your consideration, from my perspective, before we go back to the beginning, under weighing the evidence, can I take out, has the witness been convicted of a felony?
Yes, sir.
Because there's no such thing in this case. Okay.
Correct.
And how about, my default position would be to leave it in, but any pressure or threat been used against the witness that affected the truth of the witness's testimony? We could have had that in this case, but I don't think we is there any of that? Anybody want that?
No, sir.
State,
I couldn't quite hear, I'm sorry.
has any pressure or threat been used against the witness that affected the truth of the witness's testimony?
Not
Both
present.
sides agree. I'm going to take that out. So now we have in that section 7, with the extras being offered to receive money, which there is, and make an inconsistent statement, which there also is. And all right, so going to the top, any objections to the way I have it? You may, I don't know if you caught this because the last version I sent you, I don't think I alerted you to this, but there was one section I added in, unborn child, where it should be. I don't know if you caught that, but it's there now and it's proper in one of the unborn child instructions. I think it was actually on what should be page 5 for you, lesser included. That last sentence, the lesser included crimes of first degree murder of an unborn child or second degree murder of an unborn child and manslaughter of an unborn child. Before it said just second degree murder or manslaughter, so I just added that in. It's a very slight tweak. You may, if you see that. But. So we have introduction, statements of charges, introduction to homicide, justifiable homicide, excusable homicide, first degree murder as to count 1. Count 2, first degree murder of an unborn child, lesser included crimes, and then second degree murder, lesser offense as to count 1. Manslaughter as to count 1, second degree murder of an unborn child as to count 2, manslaughter of an unborn child as to count 2. Plea of not guilty, reasonable doubt, weighing the evidence, defendant not testifying, defendant's statements, rules for deliberation, cautionary instruction, verdict, single defendant, multiple counts. As to all of that, any objections or suggestions before I get to the part Mr. Cormier mentioned, which is, I'm going to get to that, what I have now. You can see what I have as far as it's the second to last paragraph. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Most, but not all, of the exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to examine an exhibit in evidence that was not sent back with you into the jury room, please let us know and we will bring you into the courtroom to do so. That's my standard instruction. I don't touch the issue about rehearing testimony at this time. If they have a note, we do. And what I was alluding to when I spoke to them about that was the default position is to play the entire testimony of those 2 witnesses, which is the safest, more proper thing to do. I have had it sometimes, and the law does allow, if they specify to us one particular place, you could do that. But in this case, it's going to be extremely difficult. I'm not sure how they would do that unless they were going like section 3 or something like that, as Mr. Richardson was referring to it. If they did that, perhaps there would be an agreement, but otherwise it'd be the default position. And those portions are really not very long anyway. So my default position would be to do that, but it's not addressed in there. So do you want some time to look over what's there and see if you have any objections to it before I actually instruct the jury?
Well, page 2.
Page
You go to
2.
Count 2. In element 2, there's just a typo for the name of the defendant. Actually, and also in element 1.
You're saying page 2. I have page 2 is excusable homicide.
So do I.
Oh, no, I'm sorry. I'm sorry. Count 2, first degree murder, no more child.
So, yeah, it says so
Page 5.
Escalera. So Escalera.
Oh,
No, I think
that.
it's spelled
Okay,
wrong.
gotcha.
Yeah, it's spelled wrong in number 1 as well.
It is spelled wrong in one?
Yes, it's an
E-R-A.
E-R.
Oh, okay, gotcha.
And I think in the other count, you had his middle name.
Let me see, hold on.
Sometimes it has Tanya's middle name and sometimes it doesn't.
Her middle name or his?
His.
And hers, sometimes she's referred to as Tanya Wise, sometimes she's referred to as Tanya Esther Wise.
Did anyone have a problem if I just get rid of the middle names and we say Jose Soto Escalera and Tanya Wise? Because middle names, like, why are we,
No
it's like a wedding
Okay.
invitation and stuff, you know?
No objection.
Okay, so I will go ahead and do that. Let me see, hold on. Let me go ahead and do that. As you're reading over the rest of them, just taking my time and without using control find, just going through it. So don't make any other.
We don't have any objections or additions.
They look good. Okay.
Yes.
State's still looking over the instructions, right?
Yeah.
Okay.
I have no objection to that.
Okay, let me finalize the issue about names. The instructions finalized?
Probably.
Okay, do that. What I'll do tomorrow too is, it's my normal practice in reading the instructions to explain the verdict form. I won't do that. I'll read them the verdict part, but I'll explain the verdict form to them after your arguments tomorrow before they go back, because it's normally, that's the purpose of that. You're about to go back and deliberate. Also, submitting case to jury, I should probably read that tomorrow. So I'll just stop at single defendant, multiple counts. Tomorrow, I'll reiterate verdict, single defendant, multiple counts, and submitting case to the jury, explain the verdict form, and then send them back tomorrow. But at least I'll get the full instructions on the law at this time. Do you just want to forego your closing arguments altogether? No. Right. I think I'd urge you to do your closing argument. All right, the jury is present. The state has rested its case at this time. Does the defense also rest its case at this time?
The defense rested.
Ladies and gentlemen of the jury, both sides have now rested their case. What we would normally do at this time is do the closing arguments, and then I would conclude the trial with the jury instructions and have you deliberate. We're going to depart from that and use an alternate procedure, which is perfectly fine and legal and perhaps better for the situation. What I'm going to do at this time is instruct you on the law as agreed upon by the lawyers, and then they're going to make their closing arguments to you tomorrow morning, after which you'll begin to deliberate on the case. The advantage of this is you'll have heard the law already as an advantage to you understanding their arguments to put it into context. But please remember something I instructed you on throughout the trial, which is do not form a definite or fixed opinion on the merits of the case until you've heard all of the evidence, the arguments by the attorneys, and the law as I instruct you. And it was stated in that sequence because that's normally the sequence. So you're going to hear the law, but don't form any definite or fixed opinion until you've heard the attorney's arguments tomorrow. And of course, until the time I send you back into the jury room, don't discuss the case with anyone, including your fellow jurors. I suppose what I'm saying is the fact that I'm going to instruct you on the law now is not an invitation to start your deliberations, which are actually mentioned in the instructions, that you don't start your deliberations until tomorrow after the attorneys make their final arguments to you. Also, I'm going to be reading the instructions to you. Tomorrow, after the arguments are made, these instructions will go back with you into the jury room, and I'll have a copy for each of you individually for you to refer to should you need further reference to the instructions during your deliberations. And members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jose Soto Escalera, the defendant in this case, has been accused of the following crimes. Count 1, first-degree murder with a weapon. Count 2, first-degree murder of an unborn child. Introduction to homicide. Jose Soto Escalera is accused of first-degree murder in counts 1 and 2. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Tanya Wise and her unborn child were killed by Jose Soto Escalera, you will then consider the circumstances surrounding the killing in deciding if the killings were first-degree murder or second-degree murder or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. I now instruct you on the circumstances that must be proved before Jose Soto Escalera may be found guilty of first-degree murder with a weapon, first-degree murder of an unborn child, or any lesser included crime. Count 1, first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tanya Weiss is dead. 2, the death was caused by the criminal act of Jose Soto Escalera. And 3, there was a premeditated killing of Tanya Weiss. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. An issue in this case is whether Jose Soto Escalera did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find that the defendant did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was not a reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And Jose Soto Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tanya Wise. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should not find him guilty of first-degree premeditated murder. If you find that Jose Soto Escalera committed first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of first-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto Escalera committed first-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of first-degree murder. Count 2, first-degree murder of an unborn child. To prove the crime of first-degree murder of an unborn child, the state must prove the following two elements beyond a reasonable doubt. 1, Jose Soto Escalera caused the death of the unborn child of Tanya Wise by killing Tanya Wise. And 2, Jose Soto Escalera's killing of Tanya Wise was first-degree murder, as I have instructed you in count 1. Unborn child means a member of the species Homo sapiens at any stage of development who is carried in the womb. When there are lesser included crimes, in considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which Jose Soto Escalera is accused, there may be evidence that the defendant committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crimes of first-degree murder with a weapon are second-degree murder and manslaughter. The lesser included crimes of first-degree murder of an unborn child are second-degree murder of an unborn child and manslaughter of an unborn child. Second-degree murder, a lesser included offense as to count 1. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Tanya Wise is dead. 2, the death was caused by the criminal act of Jose Soto Escalera. And 3, there was an unlawful killing of Tanya Wise by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jose Soto Escalera did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. in order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jose Soto Escalera was in fact so provoked and did not cool off before he committed the act that caused the death of Tanya Wise. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should not find him guilty of second-degree murder. If you find that Jose Soto Escalera committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto Escalera committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of second-degree murder. Manslaughter, a lesser included offense as to count 1. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Tanya Weiss is dead. And 2, Jose Soto Escalera intentionally committed an act or acts that caused the death of Tanya Weiss. Every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Jose Soto Escalera committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, attempted to use a weapon, you should find him guilty of manslaughter with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used to inflict bodily harm. If you find that Jose Soto Escalera committed manslaughter, but you're not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, attempted to use a weapon, then you should find him guilty only of manslaughter. Second-degree murder of an unborn child, a lesser included offense as to count 2. To prove the crime of second-degree murder of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto Escalera caused the death of the unborn child of Tanya Wise by killing Tanya Wise. And 2, Jose Soto Escalera's killing of Tanya Wise was second-degree murder, as I've instructed you in count 1. Manslaughter of an unborn child, also a lesser included offense as to count 2. To prove the crime of manslaughter of an unborn child, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jose Soto Escalera caused the death of the unborn child of Tanya Wise by killing Tanya Wise. And 2, Jose Soto Escalera's killing of Tanya Wise was manslaughter, as I've instructed you in count 1. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, whether, when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. And counsel, I'm striking that next sentence in this particular case. Whatever verdict you render, start over with that sentence, little tongue twisters here. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proved beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And tomorrow, after the arguments, I will show you the verdict form and explain it to you before I send it back with you for your use. Single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crime charged. The last instruction is submitting the case to the jury, which I'm going to do with you tomorrow. So after the arguments are concluded, I'm going to reread to you the few of the last pages here before I submit the case to you. That concludes the instructions at this time. Tomorrow we will reconvene at 8:45 in the morning, just as we did today. Remember, I cannot overly emphasize, you have not heard the arguments of the attorneys. Don't form any definite or fixed opinion about the merits of this case at this time. The same rules that govern your conduct remain in effect. Of course, in abundance of caution, please remember, avoid any exposure to any extrajudicial information. Don't talk to anyone. Don't do any research about the case or the people or the issues involved in the case. To be sure, you can find your consideration of this case only to the proper evidence and nothing else. Avoid all of the media coverage of this case. With that, enjoy the rest of your day and your evening, and we'll see you tomorrow morning. Please leave your notes on your chairs. Jury has exited. Before we break, let's take a look at the verdict form as well, just to be sure there's no objections to that. Oh yeah, I wanted to take out the form as to count 2. The state had put in a weapon, which doesn't apply to count 2, so I'm going to take that out. You remember that? Okay. And I also put unborn child in the language as to count 2, which fits the charge. It just said first-degree murder. It didn't say unborn child, so I have that as the count 2. And it is still September, so that's correct on the verdict form, right? And so right now the verdict form says what was that? We the jury find Jose Antonio. I'll get rid of the Antonio. Do that also on the top there. Verdict form. We the jury find Jose Soto Escalera as to count 1, select only one, guilty of first-degree murder as charged in the indictment, guilty of second-degree murder as a lesser included offense, guilty of manslaughter as a lesser included offense, or not guilty. If you find the defendant guilty as charged or guilty of any of the above, there's an error there. Above lesser offenses. I'm adding a word there. You must next determine if any of the following has been proved beyond a reasonable doubt. Check yes if proved beyond a reasonable doubt. Check no if not proved beyond a reasonable doubt. During the commission of the offense, the defendant did carry, display, use, threaten to use a weapon or attempt to use any weapon, yes or no. Count 2, select only one. Guilty of first-degree murder of an unborn child is charged in the indictment. Guilty of second-degree murder of an unborn child, a lesser included offense. Guilty of manslaughter of an unborn child, a lesser included offense. Not guilty. So say we all. This blank day of September 2025, 4-person. So that looks good. I'll print out a few copies of that to give to you all and for myself here. And anything else before we break from the case? From the state?
The only request for tomorrow would be to have it maybe a 5 or 10 minute bathroom break after
the defense part. Well, that reminds me of another issue. So what we should do for the bailiffs, take the lunch order of the jury as soon as possible because they're going to be here at lunchtime for sure. Are we still using roots or whatever? Oh, there you go. That's less offensive to the jurors than the other miserable food that we were offering them, like some kind of sprouts and something. So that's good. Let's take their order so that it's there and we get the lunch because it's going to be right about lunchtime that we're going to submit the case to them. And as far as the bathroom break, that's perfectly fine. In fact, Miss Minton, if you want one after they get finished too, I'm just kind of giving you a wink and a nod, and we'll do that as well. All right. And so if there's nothing else, how about this? Maybe this is a good time to check over the evidence that we absolutely sure there's nothing going back that shouldn't.
They've already locked it up.
Oh, okay.
I mean, the fact that you were looking at the block is really, it's not going to take that long.
They've got that much.
Just to avoid calamity.
The items that are not fully admissible, that we've done those. I've got 160 exactly,
170, 183.
which are not going back to the jury. But if they did, is there any request for a laptop to go back to view other stuff? There's not. So we're kind of doubly safe. Even if it goes back accidentally, they can't view it anyway. So they don't have electronic.
Well, no, I take that back. The defendant's interview.
And the
defendant's
surveillance videos are going back there.
Right. So we need to
will
be
have
extra cautious to make sure that those don't go back. And the other item that's not, just make sure the other items that are not into evidence do not go back into the jury room, because there's several that were marked that are not into evidence. Right.
Yeah.
I'm going to strike that. You all caught that. That was good, Johnny, on the spot. The sentence that I said was, I decide the sentence. Well, no, well, Judge, why did we spend 2 weeks in death qualification? Yeah, right. That was a good catch by me. I'll strike that and reprint the instructions for myself and for the jury. All right, and then we'll be adjourned until tomorrow morning at 8:45. Thank you.
So we have closing arguments tomorrow. Closing arguments tomorrow. I will continue to look and see if we can find the rest of our day for our hubby drug trial. I don't know. It hasn't posted back up there or anything. So I'm assuming they have to do some editing. I don't know. I wonder if they showed a juror or something. It's so crazy because it happened at the same time that Barbara was like, one of the jurors was falling asleep. And then all of a sudden the feed cut. So I don't know, but that case is probably going to be going to the jury too. Yes, I will look at that and see if we can find anything for that. I think that for our Take It to Trial After Dark, we'll do that tomorrow night, and we will have a panel discussion on all the cases that we covered this week. I wonder if it was because they said a whole address out loud. I have no clue. I don't know. I don't know. I'm gonna find out when they put it back, when they figure it out. We'll find out something. Hopefully they put it back up there. If not, then I have to fish around and see if Court TV will post it. Because we were already behind and nobody else. I think we were like the only, at least I only seen us covering it besides Law and Crime. I think some other channels are covering now, some other content creators, but I really didn't find many like when I will put it in there. So I don't even think nobody else is really like covering it like we were. Yeah, but I can't even understand why they would do that for the ME taking this stand, because all the other MEs talk. I mean, it wasn't like it was gruesome, or at least not from my understanding, is that he was choked, right? So the prosecutor, she even showed an example. Remember, she was like, he was like this behind him. Ooh. So she was more dramatic than what the ME gonna be. I don't know. But I guess we will see. Yeah, and then I got some yeah, so we'll see in regards to that. I'll keep searching around. If I see anything that comes up tonight, then we'll schedule and we'll kind of get in early. That's all. No harm, no foul. If not, then I'll just schedule our regular stream tomorrow. And yeah, we gotta find day 4. I gotta find day 4 for us to finish up. I don't know. I don't think we were in the defense case, so I'm not sure if we have much more to go, but I like to complete my coverage. Who thinks he'll get the DP? I think they'll give it to him if they found him guilty of it. Yeah, Barbara, I think that if you did see the one for the day for the hubby drug trial, I think that one is that one, when you click on it, if it's by law and crime, once you click on it, it won't let you click all the way. You may have watched it before they took it down, Barbara. We were in the middle of watching it today and they took it down. You think he gonna get life without parole, Messenger? I don't know, because it's real heinous how he did that to her and the baby. At least my opinion. I think that's a little too much. Allison said, what did I miss, guys? I've been a bust and missed a lot today. Someone please bring me up to speed, and thank you. Well, Allison, we are coming out of the Pregnant Mistress Unalive trial. We heard the intelligible audio again. We had some acting done. We had 3 actors that performed in order to try to tell us what the transcript says. Then the defense decided not to call any witnesses and they closed their case. And we just heard jury instructions, and we will go into closing arguments tomorrow. And that sums that up. So it'll be going to the jury tomorrow. I think he said he's going to get them like an hour, no more than an hour, hour and a half each for closing arguments. So morning, and it should be in a jury by the afternoon. They'll be done. I say an hour, couple hours, maybe 2-3 hours. They'll be done with their deliberations, and we should have a verdict on that one tomorrow. I don't think they're going to want to come back Monday. I think they're over it. And that's it for that one. And other than that, we did day 3 of the You said they got to be a little dramatic. They'll probably be dramatic. I mean, I can't remember the opening statements. Maybe we can look at them. We'll keep the room open for verdict watch. So, so they changed the rules. That's when they go into the penalty phase, right, Jason? Yeah, she got to be dramatic for her guy. She fighting for him. Okay, so yeah, if he does get found guilty, then we won't even know his sentencing, Messenger, until we actually get over to the DP phase, because then I'll have people come testify and look at any aggravators and things like that. So yeah, I keep forgetting it's like a two part. Yeah, 8-4. That won't be hard at all. Well, I think what we'll do is we'll call it a day. I've been up since 2:30 this morning. I'm tired. I wouldn't mind taking a nap before the kids come home, right? Look, I wouldn't mind taking a nap. Now, I can't promise you that I'm gonna stay off these YouTube streets tonight now, because I'll give me some sleep. And I wake up and I'll be like, oh, I missed them. Oh, I missed them so much. Let me just get on here and talk about something, anything. It's going to be 15 minutes and then we'll be on here for 2 hours later on the night. So If you see me out here, y'all see something, that's just me. I'm so used to being with y'all. Yes, Pretty Brown. I mean, oh, these last 2 days I've been up at 2:30 in the morning. It was worth it. Don't get me wrong, it's worth it. It's worth it. But if I can get an early day, I'm sure I'm gonna take an early day. When we get our early days, we take our early days. And when we gotta be tough out here in these streets, we be tough out here in these streets. Yeah, and I really wanna try to figure out these the Houston case. We're gonna do that one first. I think that one got the most votes. And I want to get that kind of set up. So we're gonna do that too. So yeah, cool. So we gonna work on all of that and get that stuff together. What'd you say? You can't. No, I went to bed. Like I went to bed about 10. I was like, because we didn't get home from she didn't get home from the game until about 8, 9 o'clock. And by the time I, settled down, it was like close to 10. Well, you got to pick them up. Oh yeah, my girls, they big, they older, so they get off the bus and they got keys, and I'm gonna close my door and I'm gonna go to sleep and bet nobody knock. I'm gonna give me an hour or so of sleep before they get home. At least an hour and a half. I'm gonna get an hour and a half of sleep before they get home, and then they fix their own food and oh yeah. I mean, I like them at this age, but it's actually moving too fast. Oh, okay, Barbara. Oh, okay. I got a my neighbor, their her son is autistic. It's so cute because she got the little puzzles on her little door, and it's like this little sign. And he's so cute when I see him. He's so cute. And yeah, he got a little bus that come right in front of his house. I know, burn myself out. That's why I don't know. I have fun on here, so I don't mind. It was nice getting up. And even when I was up this morning, like Marilda was here, then OnlyFans was here. Like they were here. So long as they here, I'll be excited in the morning. I'll be excited, like, ooh. Especially with this was a good case to actually be up in the morning. The hubby and hubby drug case, that was a good case to be up in the morning because it kept me up. This case right here, if we would have tried to do this one early in the morning, I probably wouldn't be able to do it. But the other case was real good. Like that woke me up. That kept my attention. I was like, attention, what we gonna find on this dresser? What we about to find in this closet? Oh, that's what y'all was doing. Oh, okay, cool. I'm learning today. Yeah, so that one, I appreciate that one in the morning. Yeah, so if anything, we'll be scheduling that in the morning tomorrow morning. Right? When some asleep, some awake, right? It's just kind of like, flip-flopping a little bit. That's when everybody is everywhere. Yeah. Yeah, because our evening, that's when Marilda sleep. That's when OnlyFans kind of sleep. We got anybody that's in the UK, they be kind of sleep. Like, yeah. He say Drunky Junior at school. Have a good one, Drunky. We about to get off anyways. All right, guys. Well, you were in the right place today where we switch up courtrooms. We get pulled from live feeds. But there's no filters, right? No fluff, just facts. So you can be the judge. All right, guys, have a great one. I will send out our schedule and everything for tomorrow. You guys have a good evening if I don't see you before then. All right. Peace.